Hi, I'm Vishmi Gamage, Senior Lecturer in Law at Horizon Campus. I know I'm here after a long time with y'all to do a video, but I thought of doing something different today than the usual videos I do. So let's go in and see what my students are doing today. Shenya, what is happening with studies these days?
Hi Miss, so we are studying the judgment of AA against Independent News and Media Limited and others.
Okay, very good. What about your friends?
So we are finding the material facts and the legal issues.
What's happening with the case name? So what did you write for the material facts?
So we found in para 3 that A is an adult who is disabled due to several sicknesses, but he has attracted both national and international public attraction because of his music talents.
Yes.
And also he can't live independently because he is disabled. He is severely disabled.
Okay.
His family initiated an action in the Court of Protection to appoint them as deputies for A to deal with his future affairs to be managed in paragraph 5.
Yes, I found in paragraph 6 that Court of Protection will have to consider medical, psychiatric evidence and also his financial records.
What about the fact that the Court of Protection is functioning privately, and that is the reason why the media made an application granting in favor of them, asking for them to appear at courts?
That was challenged by Ace Committee.
You all have got it correct. Now read the paragraph 12 for issues. I'll talk to the others and come.
Hi Miss, I found the issues. Can you check them?
Yes, sure. Show me.
Whether Headley J was wrong to conclude that there was good reason for making the order, and whether the analysis of Headley J regarding the impact of Article 10 of the ECHR on the legislative structure was correct.
Okay, you have got it right. What about the detailed reasons?
Miss, the decision is given unanimously to dismiss the appeal, right? And shall we discuss with the others also how they arrived at the reasons for the decision?
Yes, sure. Let's go.
The law that is applying here is in Part 2 of the Mental Capacity Act 2005, and according to Section 51, Subsection 2, Paragraph H, the court has the power to make these rules, and the rules that they are allowed to make is in Part 13, am I right?
Yes, you are right.
Hi guys, are you working on the case note?
Yes.
Can you show me the diagram we gave that day?
So here, as per the diagram, according to rule number 90, hearing should be held private. But court can authorize any person or execute people from hearing.
But the court will only grant the order if there are good reasons. So we can say that Rule 90 is just a general presumption which can be rebutted with the presence of good reasons.
So in paragraph 11, the court should check whether there are any overriding reasons to set aside a good reasons, and the court should make a balance and decide whether this case must be heard privately or publicly.
So to take that decision, court will have to consider three things. Court will have to consider the private nature of the subject matter, and the court will have to consider the legitimate interest of the legitimate public interest, and further the court will have to consider the powers of the Court of Protection.
So Miss, all the above are in paragraph 30.
Yes, that's right. So can someone tell me any reasons that shows the private nature of this case?
A's personal information, medical and final issues will be revealed during hearings.
The financial issues. Okay.
But there is nothing private here. A is a celebrity who has already published a biography. So his life is pretty much in the public domain.
True, that is true. But then tell me what are the reasons that are there which shows the public interest?
Firstly, A is in a public profile due to his talents and medical conditions. It's in paragraph 20 and 22. And he is unable to face interviews though he faced photographs. Therefore, he is unable to share his story by himself with public or media. And thirdly, since information is already in public domain, it is legitimate for media to publish. And at last, this unique case will give a chance for the public to get to know about how court of protection works, because in general, all the cases are privately heard.
Hi. So even though Court of Protection conduct cases privately due to the fact that they exercise the jurisdiction in relation to property and welfare of mentally incapable people, exceptions will apply if the court is satisfied with paragraph 17 and 18. Above mentioned public interest grounds are good reasons, but Justice Headley was careful not to open the case for the entire public. Court is unable to decide which part of A's life will be of public interest. It is a matter of media. This is why court allowed only a few people from media to be present. And now my friend Sakila is ready to bring you more information. No, my friend.
Yes, Timodh. In paragraph 24, the case of Mattingly against Associated Newspapers is cited. In that case, they said that if the judge is right, there is no need for the Court of Appeal to retake the decision.
So that concludes the detailed reasons for the first issue. If you have any questions, you can comment below.
Miss, aren't you helping us with the second issue?
Okay, I'll try to help you out with another video.
Okay.
Like, share and subscribe.